Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome back to Legal Ease, the show that converts legal jargon into legal ease. And tonight I'm joined once again by attorney Karabo Mvubu, and he's been on the show before. Now you recall that an extremely skilled attorney who holds 2 master's degrees. Tonight we'll be covering the topic of FICA and money laundering. Karabo, good evening and welcome.
Good evening, Mr. Ashraf. Good morning to your viewers as well. Good evening to your viewers as well.
Thank you. Thanks for joining us. I know it's been a tremendous week in the courts, so many different issues. But a critical issue for now and in the future is FICA. Just remind us, Karabo, what does FICA actually stand for? What's it an acronym for?
So FICA would then stand for Financial Intelligence Center Act. And that's a general abbreviation that is used to shorten that long and mouthful name.
Is it a government organization, FICA?
It works within the government department insofar as enforcing the Act itself and the regulations pertaining to what the Act talks to, which we'll elaborate in a minute or two.
Okay. And there was talk recently about the amendments to the FICA bill, and there was this whole thing about the president had to sign it on a particular day. Why would that have been important for us?
So it's an excellent question, Mr. Esop. First and foremost, one would then have to deal with what FICA seeks to do.
Yes.
And the first thing, really, the objective of FICA is to encourage institutions to know who their clients are. And which clients they're dealing with. And the essence of FICA is to combat money laundering, which effectively is when people take money from proceeds of crime and put it back into the economy or commerce to disguise it as a legitimate money that they've either earned or acquired through a source that is valid or that is legal. There is also the aspect where it deals with terrorism. Now, we've, of late, as you say, have had issues, some of which have gone to court. The significant case at the moment is in relation to the Gupta family, for example.
Yes.
And the question is with regards to accounts that they may have with banks, the details pertaining to the transactions within the accounts, et cetera, et cetera. And the understanding at the very least is, if, for example, an institution that is, in terms of FICA, obliged to take certain measures in order to enforce the obligations imposed to that party by that law, what can they do except to bypass the requirement of actually approaching the client first, which would generally result in a situation where the client hides their money, or alternatively not cooperate with them. So what they're trying to do then, especially when it comes to investigations, which generally are by and large criminal investigations, they're trying to bypass that, where the government in this regard was trying to implement the amendment to FICA, the purpose of which was to ensure or to allow government to search effectively or monitor monies that are entering accounts without having obtained any warrant from the relevant authorities.
So, the rationale, as I understand what you're saying, is the rationale is really to find out, know who the client is or know who the person is.
Correct.
And how that money came about, right?
That's correct.
So that money has to have a track. And the reason for that is for the authorities to be able to trace funds that are suspicious.
Correct.
Now, typically, how would that play out? There's 2 parts to this question, right?
Okay.
What does the institution have to do, and what obligations do you as a client draw?
Well, as the client generally, if I bank with ABC Bank,
Yes.
The first requirement, the first expectation actually that I have of the bank is any information that I leave or give them or volunteer to them will be kept in secret.
Okay.
And that's confidentiality, so I have that secrecy between myself and the bank. And the issue then becomes, what then if I transact in amounts that the Act has identified as suspicious amount at the current moment. If I were to deposit an amount of about 25,000 rand, the Act requires the bank to then notify the relevant investigators to pursue or direct an investigation determining or unearthing where the money came from.
So the baseline is actually moved from 100,000 to down to 25,000.
Is
it cash or any kind of?
So it is currently, as I understood, cash or any transaction generally. And the point really is that will attract, or it will be a suspicious transaction.
Right.
And the requirement is then the relevant authority, which will be a bank in this regard, must report that. And then an investigation can be pursued to determine what the source of that money or those monies are. Now, without my consent, that is in fact a violation now of my rights.
In terms of POPI?
In terms of POPI, certainly, as well as the FICA, as well as general banking laws, banking law practices. So you'll then have, for example, Section 14 of the Constitution, which entitles me to the right to privacy, which includes the right not to have any of my properties searched, let alone seized. So if that is to be done, it must then be done in a manner that is actually constitutional, i.e. in a manner that is a fair and justifiable limitation of that right. Normally what that would be is if the relevant authority has my consent. If I've consented to them passing on the information, it would not be an issue. Secondly, alternatively, if it was a criminal investigation that they had and they had a search warrant pertinent to that money or those resources, they can then pursue that. What now they seek to, or the amendment that they're proposing to make, is such that they are going to have or access my account without my knowledge and also without the relevant authorization for them to do so.
So, I mean, that's quite a drastic inroad into your own personal information, right?
It is beyond. I suppose that there are balancing exercises that one has to factor in, which perhaps the things that we can talk to just shortly. But the main essence of it is definitely on face value, it is a violation and infringement of my right.
So that looks like a double-edged sword for, say, financial institutions, because on the one hand, they're meant to report. And on the other hand, they say, but your information is supposed to be kept private. Now, if they are meant to report, who would they report to?
So they will report to the Financial Intelligence Center, which is responsible or tasked with implementing or enforcing the Act and the regulations that follow. So they'll report to the center.
And is there any liability against the center? Let's say they get it wrong, for example, or against the bank, right? Let's say I share a name with a known international felon, okay, a drug lord or something, and he makes deposits and I make deposits. Or indeed, if your account is hacked, I mean, that's a possibility, right?
It sure could happen. Generally, banks do take measures and steps to safeguard those eventualities, but it is a possibility that your account can be accessed by other hands beyond your knowledge.
And I mean, it's a possibility your account can be abused. You know, there's 419 scams that say, you know what, we've deposited money into your account by mistake, and then they ask you to reverse that and the money is then gone, right? Now, in terms of FICA, what possible claims could you, as the affected party whose information has been compromised, do you have a right of recourse against the institution or against the regulator?
Well, generally, I mean, in this regard, when monies come into your account without your knowledge, prudence is generally, or should I rather say, what we normally do is tend to throw the blind eye and pretend as if nothing has happened. But the point is there we are actually placing ourselves at risk. Because it's one thing to allege that we are not aware of the funds, and yet quite another thing to have actively pursued that venture. So the first thing that you need to do when we start noticing, even if it's not from your account so much, even if a person that you know, noticing funny and strange suspicions, you need to bring those to the attention of the bank. you then need to cooperate with the bank insofar as letting them know what the situation is. If you don't come forward and therefore the banks are not aware that you're in fact not complicit to those transactions, it will be very difficult. First and foremost, you'll have to then prove what you were doing to try and safeguard your interests before you can even sue the banks. The banks will then be obligated. So if, for example, let's work from the premise that you have notified the banks, that you have indicated and cooperated with the banks, showing them fully that you are not in any way involved in any syndicates such that you are exposed to crimes which you are benefiting from, and you are taking those monies and putting them in your account. If that is the case and the bank is well aware, and therefore their investigation of you can be seen or termed to be, frankly, malicious, there you can sue the bank. But the main essence, though, is you would have to advance and show cause that the bank acted maliciously, which is no mean exercise. You'd have to advance certain and large steps. But if you've just been quiet and have done nothing, it will be quite difficult to sue the bank. But you could sue the bank if you were able to show that the bank has indeed violated your rights and interests under those circumstances.
Now, against the regulator itself, I suppose you don't have any recourse.
Similarly, if you can clearly show a case of generally to be an investigation there. Secondly, if they then perceive that the monies are from illegal proceeds, from which then a criminal prosecution is pursued, notwithstanding your continued indications and you cooperating with them thoroughly, if they themselves pursue what can be said to be an unfair, if I can use that word, prosecution, there you could have recourse against them. But again, you'd have to. There's a higher threshold. It's not a mere. Well, I wasn't responsible, but they went after me. There must have been circumstances that show that there were malicious intents, if you want me to say that, by the body itself in coming after you.
How often does the institution have to refresh its FICA notes on you? Today I had a situation where the client was saying that she conducted business with a particular bank for payments to a London account pursuant to an international contract. And it's been going on for 10 years. And then she's now been told, but she's got to come in and FICA this thing again and bring the original documents. And she said, I can't do that. I've been doing it for 10 years. So my question is, how often can the bank demand that you FICA yourself?
There isn't at the current moment a clear delineated category of circumstances by which or under which you should be FICA'd, but generally it's within the lapse of a reasonable time. So as and when the bank perceives the information that it holds to be outdated, that then would require to approach you to verify certain details. So it will depend, suppose, on a case-by-case basis, and the facts or factors that play a role in that determination.
And you as the client, what onus is on you? Let's say you're renting a place and then you move from that place. What onus do you draw to actually go and inform the bank, look, I'm no longer there? Is that an obligation on you?
Out of good faith, Mr. Esop, you would have to notify them. There isn't, strictly speaking, that requirement. It would, of course, as I indicate, out of good faith, as a client of the bank, in particular, just for you to have a good standing with the relevant institution, that you notify and give them the details, particularly changes to information that they are holding. Otherwise, the question would be, for what good reason would you insist on the bank holding on to old information when you are well aware that the bank has, in fact, outdated information at the moment or at the time and place? But again, that in itself, there isn't a strict per se requirement obligation from you. It is out of the goodwill of general doing business where just out of courtesy, really, just notify the banks and advise them of any changes, particularly with regards to residents, amongst other things.
Okay, time for a break. Please stay tuned and join us after the break.
Metro Lifestyle Center, where you can find all brands and lifestyle products at very competitive prices. Metro Lifestyle is a one-stop shop with appliances, deco, household, textiles and many more products. Metro Lifestyle is proud of their services and assistance to every customer with staff that are trained and knowledgeable. With more than 7 decades of experience and assistance from overseas imports, Metro has the advantages of helping clients save by offering the best prices. If you're interested or seeking great lifestyle products at great prices, don't hesitate to knock on the door of Metro Lifestyle Center. Give us a call on 08611 Metro.
Protea Toyota celebrates 42 years of service to the Cape Town community. Established in 1973, Protea Toyota offers a full range of Toyota cars and light commercial vehicles, factory-trained technicians for servicing, and stock a full range of genuine Toyota parts. Protea Toyota, 189 Voortrekker Road, Bellville. Call 021 946 3324.
Are you importing or exporting products for your business? Why don't you contact Fourway for an innovative logistics solution? Sea, air, rail or road, Fourway has a solution for you.
Dinsons, a fourth-generation family-owned business since 1973, with over 4 decades of hands-on experience and warmth of a family name. We are your one-stop furniture store, offering you in-house decor advice and specializing in custom-made residential furniture, as well as the corporate and hospitality sector. All our products are locally produced, using the most exotic imported timbers and veneers. Dinsons, transforming houses into dream homes. Visit www.dinsons.co.za or contact us to set up an appointment.
Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome back to Legal Ease, the show that converts legal jargon into legal ease. And tonight I'm joined by Karabo, who is actually an attorney and a lecturer at IPCE in Johannesburg. Tonight we're covering a very, very important topic, and that is of the rules and regulations regarding FICA, more particularly money laundering. Just before the break, we spoke about the obligation or the good faith obligation. It's not an obligation in law, right, Karabo?
It's not an obligation in law, indeed, Mr.
But it's a good faith obligation that you owe the financial institution to say, look, I've changed my address for whatever reason. Could be changing jobs or whatever. Yep. But or your lease could have come to an end. But the obligation is there for you so that if there is any investigation, the idea behind FICA is that they must know who the client is and where his money came from. That is in order to stamp out money laundering and proceeds of crime.
Correct.
Okay.
And perhaps I might add there, Mr. Esop, that the obligation, though, is in law if the bank requires the information and you don't provide, alternatively, you provide misleading information. So if, for example, you have relocated or your lease has expired and you have now had to relocate it as a result thereof, and the bank asks you of your latest FICA documents and you provide old documents whilst knowing that you're no longer there, that in itself is problematic. So that can be clamped down upon. The providing of false and misleading information. But generally, out of your own courtesy, before the bank even comes to you, that would be out of good faith, out of general courtesy, really, extension to the bank.
And the viewers are reminded that they are able to call in. The lines are open. The numbers appear on the screen. And you can join this conversation or put questions regarding this. Karabo, let's say I'm a foreigner and I'm on a refugee Section 22 permit. Oh, we have a caller. Caller, please go ahead.
Hello?
Hello?
Hello, can you hear me?
Yes?
we can.
Yeah, can you take this call?
Yes.
Yeah. I'm speaking from Port Shepstone.
Yes.
It's regarding my business that lost millions of rands due to the computer laundering. The computer guys have fed me with the computer, the staff. Can I take the matter up and see if I can go and see Hawks or somebody like that? Because we had no proof at the moment. But we know that people have taken the money, they bought new cars and bought houses and so forth.
So let's just understand your question.
Yes.
You had an account with the bank,
Yes, yes,
and that account was then fleeced, or
correct.
monies were removed and not by you.
Yes, correct, right.
And you suspect that it's certain staff members, correct?
Yes, correct, right.
And you want to know what recourse you have.
That's correct.
Okay, Karava?
Very well. What steps have you taken at the moment, just to follow?
No, 2 years ago, we took steps with a private investigator, and we had no joy. When we went back to the CID, they said there's no case. I know what's happened there, I don't know. So I don't know what step must I take now.
Okay. I'd just like to ask one more question just to be entirely clear. Was this money in the possession of your employees, or was this money somewhere else where they then subsequently gained access to it?
No, the money was somewhere else, gone somewhere else.
It would sound to me more of a crime, which is the crime of theft in this regard.
Right.
So there you would have to then firstly open a charge on theft, provided of course you've got the necessary details sufficient for police
IDs and so forth,
investigation.
right, okay.
All you would need for that purpose is the people that you are suspecting of having committed the crime,
Right.
and their details. Really, that would be sufficient. You'd also then need the time where you allege that the crime was committed, and some proof. I'm not sure if you've got any documents that are lying with that can indicate that those monies or those resources were taken.
It was not taken physically. It was done by bank to bank.
Correct.
And we couldn't pay them at all.
So what can happen then there are two things that you can do. From your side, I suppose it's quite easy. You can pull out your bank statements and everything else to indicate that those monies have since been taken. The second thing that you would then do under those circumstances is request a search warrant. Have a search warrant for that specific person that you think the monies were transferred to, in order to determine whether indeed the monies went there, in which case you will link the monies being taken from your account and moving on to the next account. And that's effectively a case of theft. That would be theft. And then in terms of employment, did you take any disciplinary procedure?
Not fraud, is it? No, it's theft, eh?
That's theft. No, that's theft.
Okay. No, that's fine.
In relation to the employees, did you take any disciplinary action, or did you just leave it at that?
We have to just like that for the time being.
Okay.
Okay, I'd like to just come in and add the following. If a period of 3 years has passed, then your claim has prescribed. So if you haven't issued a summons, which is delivered to them before the 3rd year anniversary, then you have no civil claim against the...
no civil case, eh?
So that is for the recovery. Now, in the Natal area, you should go and see the head of the specialized criminal court and lay a charge and say, this is my case against X, Y, and Z.
Yes.
Now, you should be able to say to them that you want the matter investigated. Now, that claim doesn't prescribe. You've got 30 years, but you don't want to be waiting around for a long time. To be proactive. So you do have recourse. I wouldn't suggest that you go to the Hawks and all of that now. There are highly trained prosecutors in the specialized criminal courts.
All right.
And they would be able to take a proper case and appoint an investigating officer for you. And then you can keep your hand on that pulse of that investigation, and you can certainly provide that investigator with all of your theories. Look, they've got a new car, and cars can be traced via their registration, and then you'll know who the owner is. And then you'll find out how it was paid for. And, if it's bank to bank, you've already got a pathway to maybe a conviction.
And just to add on to Ashraf's point, and if the prosecutors then decide not to prosecute your matter, you yourself can prosecute. And all you have to do there is to request the prosecutor to give you a document in writing that indicates that they're refusing to prosecute the crime. But once they've given you that document, you'll then assume all the power as a prosecutor has to pursue the investigation as well as the prosecution of the crime. Together with that document, which is referred to as a nulla prosequi, it's a certificate that the prosecutor will give you. You'll then have to deposit an amount of about 2,500 rand to your nearest court where where you'd be prosecuting the case. So if the prosecution is refusing, you can certainly prosecute yourself.
I see. Okay.
Well, last but not
Because
least,
at the moment now, I am completely broke. They did me down badly.
a criminal
That's what I
case
can
will
say.
cost you nothing. You can
Cost you
go.
nothing, eh?
You can go to the prosecutor,
Yeah, right.
and a
Yeah,
civil.
here in Port Shepstone or in
No,
Durban.
the commercial crimes unit, wherever it's situated in Natal.
Oh, I think it's in Durban.
Yeah, you should go there. But
Commercial crime unit, eh? I see.
you should have your story right. I mean, if you've employed a private investigator,
Yeah, right.
it's surprising that nothing came up. I mean, let me ask you this question: did the bank that transferred the money to the third party,
Yes.
did you get those records of those transfers?
No, we didn't get the records at all.
Okay, there's a section 205 of the Criminal Procedure Act that entitles the investigating officer to ask for all information necessary. So he's empowered on the basis of that section to even go to cell phone records and to go to bank records and do a full investigation, and it wouldn't cost you anything.
I see. No, that's fine. No, thanks, Sergeant. It's called the Criminal Investigation Unit, eh?
Crimes investigating, correct.
A private, a
Specialized.
criminal.
No, it's a specialized commercial court.
Oh, specialized commercial court, I see. Specialized commercial court. No, fine. Thank you very much. Eh?
Okay, thank you for your call. I hope we've been able to help you. Just time for a short break, Rab. Please stay tuned. Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome back to Legal Ease, the show that converts legal jargon into legal ease. Tonight, Karabo and I are discussing the matter of FICA and money laundering. Karabo, we had a very interesting call just before the break. I think that caller is quite satisfied with the information given. But we really want to talk about money laundering now. What is money laundering? How is it defined?
So money laundering, Mr. Aesop, is, if I can use loose terminology, is when people clean their money with the intention to disguise where the money actually came from. There are three stages that are involved in money laundering. There is one that is referred to as placement. Effectively, placement talks to the situation where the person acquires the money and then they now place it within the institutions, and then that is followed by, it's like, for example, to carry that thought through, where a person has acquired the money through the sale of drugs and they take the cash that they've received and deposit into a bank. Layering then is the general process where, which is the second stage, is the general process where now the money is assimilated into the commerce. You can't tell, actually, you can't differentiate the money in that stage, or at least the differentiating the source of the money becomes all the more and more difficult. And the last stage is integration, where now effectively I go to the bank, withdraw the money, and buy myself a house, buy myself a car, buy myself whatever other accessory that I'd like to purchase for myself. So those are the stages of money laundering, and the point is there's a crime involved somewhere where I get this money, and then I need to ensure that the money is not traced back to the crime. Because if the money is traced back to the crime, generally what would happen is it would be forfeited to the state. After, of course, the criminal investigation, I would be convicted and I would lose the money. So the point is for me to hide where the money comes from and make it seem as if there's a legitimate source where I got the money from, such as employment, such as bartering, or whatever other lawful activity.
Mm-hmm. On that point, let's take this example, and I don't know if this was credible or not, or if it was just a social media thing. The heist at the airport, it was alleged that one of the suspects had actually bought a sports car. I mean, that would have been a very, very difficult thing to prove. But what stops him or anyone else to walk into a dealership who's not a financial institution, put your cash down on the table and say, I want that car? Does the dealer draw any onus of saying, I need to know where this money came from?
The dealer itself so much wouldn't have that obligation. The dealer has an obligation to notify the center. So the dealer would pencil that down as a suspicious transaction, in which event they then need to follow suit. But the long and short of it is that that person generally can get the money from a crime, and they can certainly go directly to a dealer and in cash. But I mean, it's quite suspicious if a person is going to buy a vehicle worth millions and millions of rands in cash. One has to be suspicious. But again, at the same time, there is a conundrum where you are faced with, for instance, I mean, no harm, foreigners. Foreigners generally would be required to have their monies up front, especially when they want to get vehicles or things of that nature. Generally, I was surprised to hear this from a friend of mine when I asked him. He's got a secure employment, he has a residence, he's got a passport. Why didn't he buy a car on installment? Surely banks would give him the car. And he responded to me and saying, well, banks require us to dealers require us to buy our cars cash. So again, that would be lost in such an instance where the person's identity is also unknown. But the point is, indeed, the dealership would have to report.
So it actually, that obligation goes beyond the financial institutions, right?
Correct.
That's quite onerous. I mean, money can be laundered in various ways. I know one of the popular ways is that if you're buying a house, say for 2 million, and you actually on the offer to purchase note it as $1 million, and then you arrange with the seller to pay him the balance in cash. That's another way of laundering it, right?
Correct.
But I mean, you're just transferring the burden to the seller, because he has to sit with this cash, and cash is no longer king. It's very dangerous to have cash.
Nowadays in particular, certainly. I mean, another easy example, I suppose, is in our fraternity. If we have a client that comes to us and they say they've got a case that they'd like us to investigate and pursue, we have generally trust accounts with various banks in the country, or any bank in the country generally. They deposit the money into the trust account. Suddenly the person says, no, I actually don't need to pursue this investigation, or sorry, I don't need to pursue this case anymore. That's another example of how the money can be laundered, where a person uses a legitimate source such as an attorney's trust account to deposit the money and then subsequently request a refund. And generally, when the money is refunded from an attorney, it could never be traced back to the original source.
So the obligation to investigate and know who your client is and where his money comes from is very, very wide. It includes attorneys. It could, I suppose, include doctors, any professional. That you give a mandate and then you withdraw the mandate and you say you want your money back.
Correct.
Wow.
The point is that duty to know your clients and appreciate where the resources that they hold are coming from legitimate sources is imposed on anyone such as the parties that you've mentioned. And indeed, when there is a suspicious transaction, they then have to inform and notify the relevant authority, which is the center.
But a very difficult balancing act. I mean, imagine if I have to ask my client, so where you got this money from? You know, wouldn't that be insulting, especially where you say if you deal with foreigners that come in with cash and it's so much easier for them. And you say to him, but where have you got this? Wouldn't he take umbrage to that?
Ordinarily, that would be the case, but all the more, your obligation is not so much to investigate your client. Your obligation is merely to refer the matter to the center and say, look, I have a client, these are the details, suddenly or of late I've acquired or received a very suspicious transaction, and the center will then pursue the investigation itself. So it will be the center that interrogates or questions or interviews the client. You wouldn't have an obligation in that regard, because in any case, if you did, it would strain your relationship between you and the client.
An interesting thing for money laundering, I know in the past, people used to say they had the winnings on horses, and they would be able to then justify a gambling win as the means of having come into large sums of money. Are you obliged to actually say to him, go and prove me, give me your ticket, because the ticket is taken in, isn't it?
Correct. So it again, you as the other side, or you as the person who's assisting your client, you don't have that obligation so much. Yours is merely when that person brings in the money. I do know some of our good friends that don't use banks, and they prefer to use their mattresses as banks. They will generally have large amounts of money. Those people that which are not that many nowadays, that are scared of banks and all that. Those people who, let's say, for example, they need to buy something and they come with large amounts of money, they, at that time, being your client, you don't have the obligation to question them or subject them to any interview of any kind. Safe to say, once you have satisfied yourself that the person from the general transaction with you in the past has suddenly brought an amount that you wouldn't expect them ordinarily to have. So amongst other things, it's a person, for example, who works a 9-to-5 job, and they've had a standard salary for years, and suddenly they've got this large excess amount of cash. You yourself don't have to ask this person, where do you get this money now? All you have to do is, once the money has been deposited, refer the matter to the center by reporting the suspicious transaction.
What happens to you if you fail, Karabo?
Well, there can be very serious consequences that can follow. You can in fact be criminally charged. You can be a civil action. A case can be pursued against you. If it's that serious and it's that dire, your license, insofar as your FICA approval, will be revoked, in which event generally you'll struggle to trade. So it can be quite drastic.
Karabo, earlier on I saw there was an offer to the first 5 callers for a course. Do you offer a course?
Correct, Ashraf. So we offer courses at the IPCE, which are generally seminars. The seminars are in POPI, refugee law, in FICA, which is generally in the banking sector. So it would be FICA, it would be the NCA, which is the National Credit Act. It will be the Consumer Protection Act, amongst other series of legal material that people need to be taught, or at least brought their attentions brought to. So we offer seminars in those, and for the first 5 callers, we had indicated that we'd give those first 5 people free seminars of their choice.
And Karabo, with regard to the regulator, where let's say you are not a bank or a car dealer, but let's say you're running a store, for example, and it's not uncommon for people to come in with large amounts of money to buy, let's say, ordinary goods, daily goods. Again, I mean, isn't that very, very difficult to try and monitor when a guy comes in to buy clothing, for example? Would that be a situation where they use that as money laundering?
It will be, in this regard, quite difficult for a person to purchase clothing or food items for the threshold amount. The threshold amount, as we know, is 25,000. So food worth 25,000, clothing worth 25,000, will depend, I suppose, on the store that you go to. But safe to say, if, for example, it's one of the fashion stores where you do have prices that can generate to those levels or to those amounts, then indeed, under those circumstances, the person would have to register as a FICA member, and indeed will then have those obligations imposed on them. But if you are dealing with the generally small amounts of money where you don't receive large sums of money, you wouldn't ordinarily have to register with FICA, and you wouldn't therefore have that obligation.
Well, it's time for another break. Please stay tuned and join us after the break. Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome back to the last quarter of Legal Ease, the show that converts legal jargon into legal ease. And tonight Karabo has been educating us about FICA and money laundering. We were just talking generally about other avenues of how money laundering can be used by using your businesses and what obligations you draw. Karabo, we took the example of clothing and food and cars, but certainly electronic goods are quite expensive, and so are watches, and the typical, let's say, a large jewelry store in Sandton often gets foreigners, and they come in with large amount of cash. Isn't it a bit onerous then for the storekeeper to take down the person's details and then say, okay, I've have the obligation and I'm reporting it? But imagine if a foreigner buys a watch for 40,000 and you ask him for his passport, or it's a bit odd, isn't it?
Under those circumstances, Mr. Asaf, it will be very, very odd.
You'd lose customers.
You can definitely lose customers. People will generally not want to trade with you. But the long and short of it really is whether or not it is a suspicious transaction. So generally and by and large, the people you'll be dealing with, albeit I'll be stereotyping in this regard, will be people that generally would be, on appearance, I suppose, if I stereotype, will seem to be well off in the sense of the word, not so much to suggest anything thereof. And the point is really, if you've got an idea or a vague understanding of the person's means, and they suddenly can come to you to produce or give you more than what you anticipate that they would have, under those circumstances, then certainly you'd have to. But of course, I mean, generally stores, it's a once-off, it's an in and out type of environment, type of setup. You wouldn't so much have to accept, for example, if you're dealing with stores that open accounts and all that wonderful things that they normally sometimes do offer. In those instances, those people will have that obligation. In which event, certainly when you have strange transactions within the accounts that have been opened, then the store would have to report on that.
A reminder to our viewers that we're in the last quarter and the lines are open and you're welcome to call in. And if you are one of those callers, you could qualify for a course with Karabo at IPCE, here based in Johannesburg. But I think, Karabo, what you're saying is the bottom line is suspicion. If there is something that makes you uncomfortable about this particular client or customer, there's nothing untoward to ask him if you have any form of identification. And if you say to him, look, I'm legally obliged to just report this, and that customer, if his own proceeds are legal and not of a dubious source, he won't have any difficulty with saying, here's my identity or my passport. So you have a discretion.
There certainly is a discretion, but there is also the difficulty where we generally don't like to give away our information unless otherwise we fully appreciate what the reasons behind that is. So even I would be uncomfortable if I went to a store and they suddenly say, please, can I have your ID? I would certainly ask, for what reason?
But then you're an expert on POPI and you know that your personal information is personal. Correct. And shouldn't be given out.
Correct.
But the man in the street doesn't know that POPI exists. You know, that you can, even the foreigner, I dare say, doesn't know there's this law that says your information is protected.
Correct. Currently, there is a wonderful breakthrough. I had an incident a few months ago, probably a year now, where I received a call from one of the insurance companies. And they wanted me to confirm my identity, of which I refused to. And then I subsequently asked where they got my details, and it so happened that they got my details from a company that I've never interacted with. And the first question that came to my mind is, how exactly did I get my information? Who's passing on my information, etc., etc. Under the old regime, well, that's it for me. But now with the POPI coming into operation, I certainly can have recourse. I can definitely approach them with a little bit more force behind my tail, as it were, and request them to own up and take responsibility or accountability for them possessing my information to begin with, and secondly for passing on my information without me knowing. So in this regard, certainly there is POPI that protects people against the distribution, or at least protects people's information from being distributed.
So just to come back to FICA, if I'm suspicious of a particular client, how should I, or who should I approach, and how should I do it? Is there like an online form with FICA, and where do I find them? We have a caller. Please hold on, Karabo. Caller, please go ahead. Caller, you
Hello.
Yes.
Hello, Assalamu alaikum. You're speaking to Muhammad here.
Walaikum salam.
I just wanted to find out that when you go to the bank nowadays, they ask for your ID number or passport number before you deposit any money.
Yes.
Yeah, so what is the reason behind that? Because before they never used to do that. Now, even if you go and deposit anything, 500 or 10,000 or whatever, they need your identity number, or they need your number. Thank you very much. If you can just advise on that. So,
thank you for the call.
Generally, banks, as we know, banks are generally the easiest targets for crime purposes, and they need to take steps to protect themselves, particularly against fraudulent transactions. So it is quite easy, at least back in the time, it would have been easy for me to go masquerading as somebody that I am not. Now they insist indeed on those details merely out of their own safety precautions, so it will be rules that they've put up. It's not so much a requirement strictly per se by FICA. FICA will only require them to know you as a client, and then to pursue anything that relates to your account in relation to that relationship. Over and above that, of course, they can then determine their own rules insofar as how people can access their monies and what rules or passes they have to pass before they can come to that. So it will be a security feature that the bank has put up, which is in this day and age a necessary feature, in my opinion, at least.
But going forward, Karabo, again, POPI, rocks up. If your passport number or ID number is taken down, you could then say to the bank, but I want to know what you're doing with this and how you're safeguarding it. So perhaps, Mohammed, there's one of three things you can do for absolute clarity. There is the banking ombudsman, there is the banking council, and there's the individual banks, and they have a public relations or division. And you could easily find out, go online and say, look, I'm your regular customer. Why is it that I need to prove my identity every time I make a deposit? And they could say to you, it's for the purposes of FICA. I hope that answers your question. Karabo, we have another caller on the line. Please go ahead, caller.
Hello?
Hello?
Yes, I'm calling from Limpopo on behalf of my school.
Yes.
Yes, the bank has notified us that we should come and renew the FICA. Otherwise, they're going to freeze the account.
Yes.
So the school has got 3 signatories, and then the other one is around in Gauteng. So we have been trying to locate him to come back. So he's not available. So what can we do? Because otherwise they're going to freeze the account.
Well, unfortunately, in this regard, you definitely have to find a way to provide the bank with that information. And indeed, the bank has the prerogative and the right to close your accounts if you are not FICA'd. Otherwise, the bank itself will be exposed to some trouble. Again, as Ashraf indicated, if you are having difficulties and struggles, there are authorities that you can approach. In this regard, you can definitely try and see if the bank couldn't help you with that process in its entirety, and take it from there. But you'll definitely have to find a way to get around that. There isn't a shortcut to it, unfortunately.
I dare say there's a real danger if you're operating a business, especially a school, and one member of the board is disappeared and can't be found. How are resolutions passed? How is the board operating? What does your constitution say? You yourself could find that you might draw the obligation for having been found in dereliction of your duties as a board member. So it's imperative either you find this person or you dissolve the board, depending on what your constitution says, and you take steps then to secure yourself. But certainly it's no excuse, I think, Karabo. That's what you're saying.
No, it isn't.
That you can't find this man, right?
But there is perhaps a provision in the Companies Act to the extent that you definitely need to pass a resolution immediately. It's Section 60, subsection 11, that allows, even if it's not the entire board that is constituted, that allows the board to come to some resolution. So you can do that, notwithstanding the absent member, and that action will still be seen as lawful.
Okay, thank you very much.
Okay, you're welcome. Karabo, we have less than a minute to sum up. I know FICA is a massive topic, and I know that people might want to take advantage of the training that you're offering. It's also correct that you train law students, is that right?
Correct. We do offer tuition to UNISA law students, and basically we have online and face-to-face students. Online students generally will get our recordings. All our lectures are recorded. You'll then get a recording via a link. You can then watch at your own leisure, at your own time, the video. The classes generally will depend on the timetable as we formulated during the course of the semester. Classes are Monday to Friday from 9 to 3. Weekends for part-time classes. So Monday to Friday is full-time classes. Part-time classes are on weekends, which generally are from 9 to 3, as well. And the classes generally for part-time are 3 hours in length. For full-time are 2 hours in length.
That's a fantastic initiative, I think, to try and train law students. We've come to the end of our show. Thank you for joining us here. And Karabo, thank you very much for coming in again.
Thank you, Mr. Yasop.
Certainly a very interesting topic, but I don't think we could do justice to it. I think for the business viewers out there, you've heard that FICA is very, very important for you to comply with. Failure could mean a jail term, right?
It can.
And a fine.
It can.
So that's quite crippling for any business. But thank you very much for having joined us. And join us next week this time for another episode of Legal Ease. Assalamu alaikum wa rahmatullahi wa barakatuh.